1994, landmark bipartisan legislation, commonly referred to as the Violence Against Women's Act, or VAWA, was passed. It was the first comprehensive federal response to addressing domestic violence, and it created protections for certain family members of abusive U.S. citizens and green card holders to obtain their own immigration status without the participation or even the knowledge of their abusers. Now, that was necessary because immigrant survivors are uniquely vulnerable, as their abusers, who typically had to begin the immigration paperwork and support the application throughout the process, were using the survivor's immigration status as a tool to wield power and control over them, essentially entrapping them within violent relationships. So what VAWA did was it allowed a pathway for domestic violence survivors to apply on their own without the participation of their abusers. And then over the next few decades, VAWA protections were strengthened through subsequent reauthorizations by Congress. So VAWA is a law that was passed by Congress, and in order for it to be eliminated or substantially changed, it would take an act of Congress. Now, similarly, the U and T visas for trafficking survivors, U visas for survivors of certain violent crimes, was created in 2000. And it was meant to be a tool for law enforcement to investigate and litigate cases of certain violent crimes. So if you're an immigrant victim, or all of your victims of a certain crime are immigrants, and they're fearful to come forward to report a crime, then law enforcement isn't able to make arrests or provide protection to the rest of the community from those who are harming immigrants in the first place.